If a crime happens today in India, the police, the court, and your rights no longer work under CrPC. Welcome to Bharatiya Nagarik Suraksha Sanhita. The old Criminal Procedure Code was written in 1898 when India had no constitution, no fundamental rights, no smartphones, no CCTV, no forensic science. It was designed for a colonial setup, not for a constitutional democracy, and the problems were structural. According to the National Judicial Data Grid, more than 70% of the criminal cases in India are pending at trial stage. Delay became routine and not the exception. The Law Commission, in its report, clearly stated that procedural delays and repeated adjournments, and not the shortage of judges, are the biggest cause of pendency in criminal cases. Technology was another blind spot. The Malimat Committee on Criminal Justice Reforms pointed out that Indian criminal procedure remained heavily dependent on oral evidences and confessions, even as crime became digital, organized, and tech driven. And the biggest gap was the victim. The Justice Malimat Committee and later Supreme Court judgments observed that the victim had no meaningful role in an investigation or trial, reduced largely to a witness in a state versus accused system. This is why BNSS is not just a legal replacement, it is a mindset shift. It moves the system from procedure for police to security for citizens. BNSS introduces time-bound investigation, mandatory forensic examination for various serious offenses, audio-video recording of arrest and searches, and a clear right of victims to be informed at every stage. In effect, India's criminal procedure finally moves from colonial control to constitutional care. The features of BNSS: Zero FIR. It is now real and not optional. Police must register an FIR at any police station, even if the crime occurred elsewhere. Jurisdiction is no longer blocking access. After the 2012 Nirbhaya case, Zero FIR enabled immediate action in sexual offences. BNSS institutionalizes this, ensuring faster medical aid, evidence preservation, and dignity. Time-bound investigation. Now no more endless files gathering dust. Charge-sheet deadlines tightened accountability on police. Now justice delayed is not equal to justice anymore. Under BNSS, preliminary inquiry must be completed within 14 days, investigation in 90 days for serious offences. Extension is only allowed with written reasons and cannot cross 180 days. Failure attracts direct accountability of the investigation officer. This replaces open-ended delays with fixed legal clocks, making justice delayed legally unacceptable and not routine. EFIR, e-summons, digital evidence officially recognized. Forensic mandatory in serious crimes. India is moving from paper to pixels. Victims must now be informed at every stage: FIR registration, investigation progress, charge sheet filing, and bail granted to the accused. They also have a right to be heard and not just examined as witnesses. On compensation, BNSS strengthened the framework flowing from Section 357A CrPC and the NALSA Victim Compensation Scheme. According to NALSA data, thousands of victims, especially of sexual offenses and acid attacks, have received interim compensation even when trials are pending. In multiple cases of POCSO and sexual offenses in 2023 to 2024, courts directed immediate interim compensation to the victims at investigation stage itself, recognizing trauma and not waiting for conviction. The message is very clear. Justice is no longer only about punishing the accused. Less arrest, more logic, power with restraint. Under the old system, arrest often became the default, not the exception. BNSS corrects this. Under Section 35, arrest is no longer automatic. The police must record reasons showing why arrest is necessary. Notice of appearance is preferred. allowing the accused to cooperate without loss of liberty. This builds on the Supreme Court's ruling in Arnesh Kumar versus State of Bihar, which exposed how routine arrest violated Article 21 and overcrowded jails. The NCRB prison statistics: over 75 of the prisoners are under trials, many arrested for offenses punishable below 7 years. With this example, in matrimonial cases, financial and minor offenses, police now issues notices first. The shift is clear from police convenience to human right protection. The uncomfortable truths. First, expanded police powers. New procedural power can still be misused. The Supreme Court itself, in multiple cases, noted that guidelines are often ignored on the ground. Second, implementation capacity. Many states lack forensic labs, trained personnel, digital infrastructures, etc. And lastly, the digital divide. Large part of India, especially rural India, lacks reliable internet. Moreover, large section of police force are yet to receive specialized training in cyber evidence and forensic handlings. Think of a mother in rural Bihar whose son goes missing. The law promises EFIR, but her villages had no internet, no smartphones, no help desk. The law exists, but access doesn't. Or take an example of a sexual assault survivor in a small town. BNSS mandates forensic examination, but the nearest forensic lab is 200 kilometers away. Trauma deepens, justice weakens, not because the law failed, but the system did. A daily wage worker arrested late at night for a minor dispute. BNSS says arrest must be justified, but without training and oversight, the handcuffs still come first, the reasons come later. Could law fail when implementation is weak? That's why the real question isn't is BNSS powerful? The real question is will its promises reach the last person in the last villages? Because for the victims, the difference between law and execution is the difference between hope and heartbreak. BNSS is not just a new law, it is a shift from colonial control to constitutional protection. If implemented honestly, BNSS can change how India experiences justice. Laws don't change society, awareness does. And now you know BNSS.